this disease. Without objection, I wish to submit the full context of the letter in the record.
Gentlelady's request is covered by General Lee.
I would also like to talk about another of our colleagues who was affected by this, Congresswoman Carolyn McCarthy. Carolyn McCarthy serves in this Congress with us, and she is a distinguished Congresswoman from the state of New York. Congresswoman McCarthy's father and brother were career Boilermakers. Each night, they brought home asbestos fibers in their clothes. Over time, exposure to this asbestos affected Congresswoman McCarthy herself, and today she is battling asbestos-related lung cancer. Her story is like the stories of countless Americans across the country. It's up to us to strengthen the health of those suffering from exposure. It is up to us to act in their names, whether they suffer from cancer today or face the prospect of severe illness in the future. Yet this Republican measure we consider today does not meet this challenge. Like far too many Republican bills in this Congress, this legislation only serves to make matters worse for the American people. The so-called, there it is again, the so-called FACT Act actually harms the American people. That is a fact, and hinders the ability of asbestos victims to obtain compensation. And how does it do this? This bill would deny cancer victims the assistance and simple justice they deserve. It would even delay compensation beyond the life of a person suffering from asbestos-related cancer and illnesses. It would invade the privacy of thousands of Americans, and it would pose a particularly detrimental impact on veterans of the United States Armed Forces who have been disproportionately affected by asbestos. Contrary to the claims of the bill's proponents, there is no need for this bill. State laws provide for adequate disclosure. There is no evidence of systemic fraud in the asbestos trust system. In short, this bill is unnecessary, it is mean-spirited, and will never become the law of the land. The Republican majority has little time left on the legislative calendar this year, just 13 days between now and December 31st, according to the schedule they have given us. In that short window, the House should focus on the most pressing challenges, priorities like job creation, economic growth, comprehensive immigration reform, or deficit reduction. Instead, our Republican colleagues have chosen to waste time on another measure, another bill to nowhere. In the name of Bruce Vento and Congresswoman McCarthy, in the name of our friends, family members, and constituents facing the daily challenges of asbestos exposure, let's work together on steps to strengthen the health of the American people. Let's preserve the privacy and well-being of asbestos victims and all American families. We can do this by voting no on this legislation. I yield back the balance of my time.
Gentleman from Virginia.
Mr. Chairman, I reserve the balance of my time.
Reserves. Gentleman from Michigan.
Mr. Speaker, I'm pleased now to recognize the distinguished gentlelady from Texas, Ms. Bernice Johnson, for 2 minutes.
Gentlelady is recognized for 2 minutes.
Thank you very much, Mr. Chairman, and thanks to the ranking member. I rise to speak against House Resolution 982. This legislation requires that Asbestos Trust, which was set up to manage a company's asbestos liability exposure, to disclose names and personal information of any individual who is seeking compensation from such trust. The negative health effects associated with asbestos has been under investigation since the early 1900s. Premature death, lung cancer, and mesothelioma are known effects of asbestos exposure. While asbestos industry officials were aware of these negative health impacts since the 1930s, it wasn't until the 1970s that evidence emerged that the industry concealed these dangers from the public. Lawsuits resulted, and in 1973, The U.S. Court of Appeals for the Fifth Circuit upheld the first successful asbestos liability suit. Today, hundreds of thousands of claims have been filed, amounting to billions of dollars in damages. The key principle behind this legislation is to prevent duplicative and fraudulent claims from being filed against companies. However, there is zero evidence to support any allegation of endemic fraud in the filing of asbestos claims. In fact, in 2011, during an examination of asbestos trusts, the Government Accountability Office, the GAO, did not find any evidence of such fraud. Make no mistake, this bill does nothing to enhance transparency and simply increases the burden on the victims who are seeking compensation for asbestos exposure and the related side effects. Instead, the FACT Act simply makes it more difficult for asbestos victims to receive compensation for their injuries. The individuals who file asbestos disease claims do so in order to receive compensation to pay for medical bills to make up for lost income when they are too sick to work. Mr. Chairman, I ask unanimous consent to file my entire statement in the record.
It's covered by general leave.
Thank you. I yield back.
Gentleman from Virginia.
Mr. Chairman, I reserve the balance of my time.
Reserves. Gentleman from Michigan.
Mr. Speaker, I'm pleased now to give to Mr. Eric Swalwell of California 2 minutes.
Gentleman from California is recognized for 2 minutes.
Thank you, and I thank the ranking member for his leadership on this issue. And I rise in strong opposition to H.R. 982, the FACT Act. It's a fact that asbestos can be found in thousands of products and locations. It's a fact that asbestos is a deadly carcinogen which kills about 10,000 Americans a year. It's a fact that trusts were set up so that victims could still be compensated, even when asbestos companies went bankrupt. It's also a fact that there's no evidence of systemic fraud or abuse in these asbestos trusts. It's also a fact that H.R. 982 would put tremendous new administrative burdens on these trusts. Fact. The result of this bill would make it more difficult for victims of asbestos exposure and their families to achieve justice. With all of these facts, the evidence is clear. The FACT Act is a fact in name only. And instead, what it claims to do is really a fiction. It's just another part of the majority's historic and ongoing hostility to victims and their attorneys who are trying to achieve justice through our courts. Instead of working to make it easier for victims to be compensated, instead of working on a whole host of other problems facing the American people, we're targeting innocent asbestos victims who are merely trying to be compensated for a wrong done to them. I urge all of my colleagues to reject this misguided legislation, and I yield back the balance of my time.
Gentleman from Virginia.
Mr. Chairman, I think we're prepared to close. If the gentleman from Michigan is as well, we would reserve our time.
The gentleman from Michigan is recognized. Gentleman from Virginia reserves. Gentleman from Michigan.
Thank you, Mr. Speaker. I am prepared to close now. I think that the case has been made that the asbestos victims do not benefit from this bill, that there is no widespread fraud or abuse, that all of the victims and their organizations of asbestos are, in fact, strongly opposed to H.R. 982, and so are we. And so it's for that reason that I urge the members of the House to soundly refuse and reject this measure, and I yield back the balance of my time.
Gentleman from Michigan yields back the balance of his time. Gentleman from Virginia.
Thank you, Mr. Chairman. I yield myself such time as may consume.
Gentleman's recognized.
Mr. Chairman, a lot of assertions have been made by the other side of the aisle with regard to the FACT Act. Let's make clear what we're talking about here. This is a bill that, in its totality, doesn't cover 2 full pages of double-spaced type in legislative language. And it simply requires that trusts that have been established to preserve the assets of companies that have gone bankrupt and have paid funds into these trusts so that future claims, future real legitimate claims will have resources available to them when it is a known fact and established by the testimony before the Judiciary Committee and by investigations in a number of publications, including the Wall Street Journal, and by reports from various state courts in more than a half-dozen states of fraud, duplicative claims. These are what we are concerned about, and this is simply good legislative reform for protection of these assets for future availability. Otherwise, these trusts, which are already reducing the amount that they can pay to legitimate asbestos victims, will run out of money altogether before all of the legitimate claims have been addressed. That's what the purpose of this legislation is. The opponents of the FACT Act have offered creative and far-ranging allegations against a measure that only seeks to introduce a modest amount of transparency into an opaque system. We know these allegations to be unfounded. The allegation that it hurts asbestos victims is unfounded. We know this because by increasing transparency and deterring fraud, the FACT Act helps asbestos victims by protecting trust funds for future claimants. The allegation that there is no widespread fraud is unfounded. We know this because there has been fraud documented in news reports, state court cases, and before the Judiciary Committee. I urge my colleagues to reject the unfounded allegations offered today by critics of the FACT Act and vote in support of this simple transparency measure. And I might add, this does not in any way delay the claims of anyone with a legitimate claim, either in state courts or in the bankruptcy courts. But what it will do is it will root out those who are making duplicative claims, who are trying to double dip. At the same time, there are people with legitimate claims that will not have any money available to them because, as we know, and as was mentioned by many of the speakers here today, asbestos is a problem that has affected many, many Americans, and it is something that can be latent for a long period of time. And we want to make sure that those victims who come along at the end of this process, who discover late in their lives that they also suffer from mesothelioma and related cancers and other diseases caused by asbestos, have the opportunity to recover, not just those who want to abuse this system by hiding their claims and not allowing proper discovery of duplicative claims and fraudulent claims. I urge my colleagues to support this well-founded, good legal reform, and I yield back the balance of my time.
Gentleman from Virginia yields back. All time for general debate has expired. Pursuant to the rule, the bill should be considered for amendment under the 5-minute rule and shall be considered as read. No amendment to the bill is in order except those printed in House Report 113-264. Each such amendment may be offered only in order printed in the report and may be offered by a member designated in the report, shall be considered read, shall be debatable for the time specified in the report, equally divided and controlled by a proponent and an opponent, and shall not be subject to a demand for division of the question. It's now in order to consider amendment number 1, printed in House Report 113-264. For what purpose does the gentleman from Tennessee seek recognition?
Mr. Speaker, I seek recognition for I have an amendment at the desk.
The clerk will designate the amendment.
Amendment number 1, printed in House Report number 113-264, offered by Mr. Cohen of Tennessee.
Pursuant to House Resolution 403, the gentleman from Tennessee, Mr. Cohen, and a member opposed, each will control 5 minutes. The chair now recognizes the gentleman from Tennessee.
My amendment ensures, Mr. Speaker, that H.R. 982 will not apply to trusts that have an internal claims audit program to ensure that claims are valid and supported. Proponents of H.R. 982 argue that its reporting and other information sharing requirements are necessary in order to ensure that asbestos victims are not committing fraud by recovering money both from trusts and through the tort system, thereby, quote, double dipping, unquote. While proponents of the bill have yet to point to any empirical evidence of endemic fraud within the asbestos trust claims process, H.R. 982, if enacted, will impose unnecessary burdens and costs on trusts and will expose claimants' private information to the unnecessary risk of inappropriate exposure that their loved ones have already suffered from. H.R. 982's additional requirements on trusts will raise their administrative costs significantly, and money used to pay these costs ultimately mean less money to compensate asbestos victims. This is particularly problematic in light of the fact that defendants can already obtain the information they want using existing discovering tools without undermining compensation for legitimate claims. The reporting requirement in H.R. 982 also raises privacy concerns. This provision requires a claimant's name and exposure history be made part of the bankruptcy court's public docket, meaning that anyone can access such information for any purpose, including purposes that have nothing to do with compensation for asbestos exposure. I recognize that the bill specifically prohibits trusts from making public any medical records or full Social Security numbers, although it does require the last 4 digits of a Social Security number to be used. I also recognize that limited additional privacy protection is available under Rule 107 of the Bankruptcy Code. Nonetheless, these measures are insufficient to fully protect claimants' privacy. As noted by my colleagues, once out in public, such information can be used for any purposes. Potential employers, insurance companies, lenders, and even those who may seek to harm an asbestos victim in some way can have access to this information without the victim's permission or knowledge. In light of these concerns, and notwithstanding the lack of any evidence of systemic fraud, my amendment ensures that to the extent that a trust already has measures in place to ferret out potential fraudulent claims, it should not have to bear the costs, burdens, and privacy risks presented by H.R. 982's requirement. If, in fact, proponents of H.R. 982 are primarily concerned about potential fraud in the asbestos trust claims process, then they should have little trouble supporting this amendment that recognizes processes already in place to address fraud while also addressing some of the concerns of those who oppose the bill. Accordingly, I ask my colleagues to support this amendment.
Does the gentleman reserve?
Reserve.
Who seeks time in opposition? Gentleman from Virginia.
Mr. Chairman, I claim the time in opposition to the amendment.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. This amendment would exclude asbestos trusts that have in place internal audit systems from the requirements of the FACT Act. There has not been any evidence presented to establish that trusts with internal reporting systems are free from fraud. On the contrary, a GAO report found that trust audit processes are designed to ensure compliance with internal trust procedures, not to remedy the fraud that the bill seeks to address. Simply put, internal audits will not be able to detect whether disparate claims are filed among several asbestos trusts or in the state courts. Excluding certain asbestos trusts from the FACT Act would eliminate critical sources of information that can facilitate the reduction of fraud. Furthermore, the amendment would not address the problem presented by plaintiffs who assert inconsistent allegations between the state court system and the asbestos trusts. I urge my colleagues to oppose the amendment, and I reserve the balance of my time.
Gentleman reserved. Gentleman from Tennessee.
I'd like to yield my time to the distinguished chairman, Mr. Conyers.
Gentleman from Michigan is recognized for 2 minutes.
Thank you, Mr. Speaker. How much time remains?
You have 2 minutes, sir.
Thank you very much. Members of the House, the Cohen amendment to limit the bill to asbestos trusts that do not have an internal fraud detection system is very appropriate. And that is because, according to the General Accounting Office, who have studied this and filed a report, they have found that in every trust that had an existing internal quality control to detect fraud, there was no evidence of systematic fraud found. And so I want to compliment the gentleman from Tennessee for bringing this to our attention. We think that it makes it a better attempt at regulating and protecting the victims of asbestos, and so I am very pleased to support it, and I hope that it becomes a part of the bill. I yield back the balance of my time in reserve.
Gentleman yields back. Gentleman from Virginia.
Mr. Chairman, I yield the balance of my time to the gentleman from Texas, the chief sponsor of the legislation, Mr. Farenthold.
Gentleman from Texas is recognized. He has 4 minutes.
Thank you, Mr. Chairman. I rise in opposition to this amendment. The amendment has nothing to do with the problem we're trying to address. Listen, all well-managed trusts, nonprofits, and business should have an internal audit procedure to detect fraud within that organization. What we're trying to combat with the FACT Act is fraud between organizations, where an unscrupulous attorney or claimant will file multiple claims with multiple trusts or in state court and in federal court, in bankruptcy court, and with the trust. So an auditor for one trust is going to have no idea what's going on in state courts or in other trusts. This is a red herring to get us away from the purpose of this bill, to protect victims by preserving the funds that have been set aside to compensate victims from waste, fraud, and abuse. This is a victims' rights bill that the proponent of this amendment, I believe, is trying to undermine with an amendment that would exempt most trusts. Because, as I said, any well-run organization ought to have internal and external audit procedures in place. I urge my colleagues to oppose this amendment that undermines the purpose of the bill and support the FACT Act, and yield back the remainder of my time.
Gentleman from Tennessee actually has 1 minute remaining if he wishes.
Thank you, sir. I'd just like to respond. You know, the gentleman from Houston mentions that this is a victims' rights bill, quote unquote. But all the victims' rights organizations are against it. There's something wrong. Something smells, and it's not Denmark. I'm happy to yield.
The point I'm trying to make is the existing victims have been compensated, and I'm glad they're compensated, but there isn't an organization in place for people who don't know they have the disease.
Sure there isn't, because they're a group that's unknown. They don't know who they are. But the victims' organizations are concerned about victims in the future. They've suffered. They project into the future. They want to help other people who are put in their position. They are reaching out in a benevolent manner. Mr. Vento's widow and her organization and the other organizations are against it. They had no voice. The only voice they have is through representatives, and they ask the representatives to vote no.
Gentleman's time has expired. Gentleman from Virginia actually has 2 minutes remaining.
Mr. Chairman, I simply would reiterate that the fact of the matter is, when you don't know who future victims are going to be, and you make a claim that somehow this is going to enrich businesses, when in fact the businesses are bankrupt and they've paid their money into a fund, that this is in interest of determining what people who have not yet made claims have, and in the interest of justice in making sure that people who have false claims or duplicative claims and are making claims to more than one trust for different claims about the same illness or claims in state court as well as in the bankruptcy court need to be uncovered, and that's what this seeks to do. And if some victims are doing that, that is not a defense to this legislation to say we shouldn't have transparency in the providing of benefits to people who have truly been harmed. So I urge my colleagues to oppose this amendment and support the underlying bill.
And yield back.
And yield back.
All time having been yielded, the question is on the amendment offered by the gentleman from Tennessee. Those in favor say aye. Aye. Those opposed say no. In the opinion of the chair, the ayes have it. The gentleman from Virginia.
Mr. Chairman, on that I ask for the ayes and nays.
The gentleman asks for recorded vote. Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Tennessee will be postponed. It's now in order to consider Amendment Number 2, printed in House Report 113-264. For what purpose does the gentleman from New York seek recognition?
Mr. Chairman, I have an amendment at the desk.
Clerk will designate the amendment.
Amendment Number 2, printed in House Report Number 113-264, offered by Mr. Nadler of New York.
Pursuant to House Resolution 403, the gentleman from New York, Mr. Nadler, and a member opposed, each will control 5 minutes. Chair recognizes the gentleman from New York.
Thank you, Mr. Chairman. Mr. Chairman, I yield myself such time as I may consume. Mr. Chairman, this amendment would ensure that the transparency the bill supporters demand from the victims of the asbestos industry will also be applied to the corporations that have inflicted so much damage and so much suffering over the years. The amendment would require that a defendant seeking the information required by the bill must himself provide information about threats to the public safety or health. This information must be provided to any other person or to any federal or state entity that has the authority to enforce a law regulating the activity relating to such information. This would go a long way to addressing the long-standing efforts by these corporations to conceal the facts surrounding their actions from the public, from their victims, and from government agencies charged with enforcing health and safety laws. Too often, cases are settled specifically in order to prevent evidence of wrongdoing from becoming public. More importantly, because of the secrecy of these settlements, other people who have been injured have no way of gaining important information about their exposure, their illnesses, or the settled liability of the companies that made them sick. Information about the concealment of wrongdoing never becomes public, and the people who have suffered have no way of knowing about the wrongdoing that caused their suffering or its extent. Governmental agencies that are charged with protecting the public health, whether in the workplace or in the home, are deprived of the information they need to enforce the laws that we have enacted. If the sponsors of this legislation really mean what they say about the need for transparency and accountability, they will support this amendment. There has been too long a record over too many decades of concealment, disassembly, and lawlessness, and too many lives destroyed because of that illegal conduct for us to tolerate the continued cover-up. This amendment will go a long way toward remedying that situation and toward correcting the unjust imbalance in the current system. Without this amendment and the openness and clarity it would provide, this bill would favor only those who inflicted the harm and would give them yet another advantage over the victims. We should stand with the people whose lives have been destroyed, with the victims, not with the corporations whose illegal and immoral conduct harmed those lives. This amendment would prevent a situation where, as part of a settlement compensating a victim, it is agreed to keep key information relevant to the public health and safety secret, so that more people will be victimized. When such terms of the settlement are kept secret, other people will not learn that a given product contains asbestos or that a given product leaked asbestos, and will therefore not know that they potentially were harmed. Any government agencies may not learn facts necessary to exercise their responsibility to protect the public. At the very least, we should be even-handed and demand of the wrongdoers the same transparency that this bill demands of their victims, a transparency which will enable other victims to understand their remedies and will enable government agencies to better enforce the law. Unless you want to assist tortfeasors and wrongdoers in concealing the effects of their wrongdoing, you should support this amendment. I urge my colleagues to vote for the amendment. I reserve the balance of my time.
Gentleman reserves. For all purposes, the gentleman from Virginia rise.
Mr. Chairman, I rise to claim the time in opposition to the amendment.
Gentleman is recognized for 5 minutes.
Mr. Chairman, one of the principal issues discussed over the course of 3 separate hearings before the Judiciary Committee was the existing impediments to information contained in the asbestos trusts. In particular, these impediments include obstacles that asbestos trusts institute against the prosecution of valid state court subpoenas for trust information. The FACT Act addresses these issues by requiring affirmative, minimal disclosures from asbestos trusts and allowing for access to additional information at the cost of the requesting party. The amendment does not address these underlying problems and instead places broad additional burdens on defendants seeking to prosecute discovery requests in state courts. Specifically, it requires defendants potentially to comply with a host of unrelated requests from unknown parties. These defendants include small businesses that played a very minor role, if any, in asbestos manufacturing, but are the last wave of companies in the plaintiff's firm's never-ending search for a solvent defendant. The burden this amendment imposes on a defendant is highly atypical, unnecessary, and would unduly impair a party's ability to assert a defense. The FACT Act, by contrast, provides transparency where it previously did not, and provides defendants with the same access to information as plaintiffs. The legislation merely levels the playing field so all parties, including other asbestos trusts and state court judges, have access to the same information. I urge my colleagues to oppose the amendment and reserve the balance of my time.
Gentleman reserves. Gentleman from New York.
Mr. Chairman, how much time do I have?
The gentleman has 2 minutes remaining.
I'll yield myself first 30 seconds, and I'll yield to the gentleman from Michigan, the distinguished ranking member. In reply to the gentleman from Virginia, the amendment refers to such party agrees to make available information. Such party is Asbestos Trust, not a small business. So I don't know what he's talking about small business requirements being imposed by this legislation by this amendment. And the amendment deals with information that the trust must make available. It does not deal with the underlying burdens that the bill places on victims, which is what the gentleman was referring to. But this has nothing to do with small business. I now yield 1 minute to the gentleman, to the distinguished ranking member of the committee.
Gentleman from Michigan is recognized for a minute.
Thank you, Mr. Nadler, for your very important amendment. As has been reported by the Fifth Circuit in the first appellate opinion upholding the product liability against a manufacturer of asbestos-contained products, the Government Accountability Office reported, quote, in the course of the first successful personal injury lawsuits against asbestos manufacturers, the plaintiff's attorney introduced evidence that these manufacturers had known but concealed information about the dangers of asbestos exposure, or that such dangers were reasonably foreseeable. And in the nearly 4 decades since, litigation over personal injuries resulting from exposure to asbestos has resulted in hundreds of thousands of claims filed and billions of dollars of compensation paid. I urge support of the Nadler Amendment.
Gentleman from Virginia.
Mr. Chairman, if the time of the proponent of the amendment has expired, I'm prepared to close and yield back.
Gentleman reserves. Gentleman from New York has 30 seconds remaining. 30 seconds.
And the gentleman from Virginia?
3.5.
3.5? You want to reserve now?
He's ready.
I yield myself the balance of my time. Mr. Chairman, the underlying bill imposes burdens on victims of asbestos poisoning because of an unsubstantiated allegation that the trusts set up by the tortfeasors, by the giant corporations that caused the problem, may be suffering some fraud, although there's no specific about that. The amendment simply says if we're going to request information of the victims, we should request minimally that the tortfeasors, that the representatives of the tortfeasors, the trusts, tell us the information that will prevent further people from being harmed. And I urge the support of the amendment, and I yield back.
Gentleman for Virginia.
Mr. Chairman, I yield myself the balance of my time. The FACT Act does not impose burdens on the victims of asbestos. It imposes a minimal disclosure requirement upon the trusts, a disclosure requirement that will benefit both plaintiffs and defendants in various courts litigating asbestos claims. Therefore, these new burdens that would be imposed by the defendant, which are substantial and onerous burdens, not the minimal informational disclosure that would help to identify duplicative claims in various courts, is a massive additional burden added to this legislation. For that reason, I would oppose the legislation, oppose the amendment, and urge my colleagues to join me opposing the amendment and supporting the underlying legislation, and yield back the balance of my time.
Gentleman yields back. All time for the amendment is expired. The motion is on the amendment offered by the gentleman from New York. Those in favor shall say aye. Those opposed say no. The opinion of the chair, the noes have it. Gentleman from New York.
Mr. Chairman, on that, I ask the ayes and nays.
Gentleman asks for a recorded vote pursuant to Clause 6 of Rule 18. Further proceedings on the amendment offered by the gentleman from New York will be postponed. It is now in order to consider the amendment number 3 printed in House Report 113-246. For what purpose does the gentlelady from Texas seek recognition?
Mr. Chairman, I have an amendment at the desk.
Clerk will designate the amendment.
Amendment number 3, printed in House Report number 113-264, offered by Ms. Jackson Lee of Texas.
Pursuant to House Resolution 403, the gentleman from Texas, Ms. Jackson Lee, and a member opposed, each will control 5 minutes. The chair recognizes the gentleman from Texas.
I thank the chair very much. We're here today for several reasons, and my friends on the other side of the aisle have their high calling and reasons of great merit that they argue. But I think we have a more devastating and prevailing reason that we're opposed to this legislation. Frankly, as I indicated early in my remarks, there are thousands and thousands of asbestos victims who are suffering from lung disease or cancer. Many of them were diagnosed late. Many of them, unfortunately, have passed. Their families are still victims. They've lost everything that they've had in trying to treat them. And now we have what we are used to saying in the community, insult to injury. Now we come with an enormously burdensome and unfair initiative. And so today I rise to introduce an amendment that I ask my colleagues on both sides of the aisle to consider because it is fair. The amendment would apply the transparency rules that they're seeking from those victims who are barely receiving dollars out of a trust that is the final results of numbers of bankrupt companies. We're asking to equally to apply these transparency rules to asbestos industry defendants by requiring asbestos companies to report information about the location of their asbestos-containing products, and the amendment, out of respect for trade secrets, will exempt that. So today, we're asking for transparency on both sides. H.R. 982 is one-sided in that it maintains the rights of asbestos defendants to demand confidentiality of settlements and protects an asbestos defendant's right to continue to hide the dangers of their asbestos products from asbestos victims and the American public. A typical asbestos defendant who settles a case in a tort system demands the utmost confidentiality, along with the right to file for bankruptcy as a condition of the settlement in order to ensure that other victims cannot learn how much they paid or which asbestos products the defendant is paying compensation. By no means do we want to help those who are hurting. We certainly don't want to give them a leg up by understanding what the process of compensation is. These same defendants now, under this particular bill, want the victims to disclose specific settlement amounts with the trust, along with product exposure information and work history. How unfair is that? On my dying bed, I have to offer and find a basis of giving you a settlement, or my family has to give it to you in the midst of our crisis. The asbestos crisis, health crisis, is a result of a massive cover-up. And therefore, we're asking today for simple fairness. If there is confidentiality on the defendant's part, and they ask for information on those who are suffering, then I believe minimally defendants can give information about the location of the asbestos-containing products to ensure that our victims are not exposed any longer. Furthermore, the trust information is already public, and I would ask why this bill is even necessary. And then the further point of controversy is that this bill seeks to override state law regarding disclosure of information. So I'm asking my colleagues to be fair, to recognize the hurt and the pain, and to support the Jackson Lee Amendment, which simply asks for those defendants, those companies, to give us a location of their asbestos-containing products. And with that, I reserve.
Sirs, for purpose of the gentleman from Virginia rise.
Mr. Chairman, I rise to claim the time in opposition to the amendment.
Gentleman from Virginia is recognized for 5 minutes.
Thank you, Mr. Chairman. The FACT Act addresses a number of issues, including state court litigants' inability to obtain information from federally supervised asbestos trusts. and the general lack of disclosure that is allowing fraud to be committed against these trusts. The FACT Act addresses these problems by introducing transparency into the asbestos bankruptcy trust system. The amendment dramatically undercuts the transparency provided under the bill by completely eliminating the quarterly reporting requirements. This removes an important and efficient disclosure component provided by the FACT Act and would eliminate sister asbestos trusts' access to information that is critical for the defense against fraudulent claims. Additionally, the amendment would place disclosure requirements on the state court party requesting information from the asbestos trusts. These disclosure requirements are unnecessary, unusual, and would severely constrain a party's ability to defend itself in state court litigation. Plaintiffs and plaintiffs' firms already have the ability to gain access to the defendant's information through the traditional discovery process. However, it is the defendant's inability to gain access to information submitted to the asbestos trusts that has created an environment that is conducive to fraud. The FACT Act merely levels the playing field, so all parties, including other asbestos trusts, state court litigants, and state court judges, have access to this information and the same information. And I would point out that when one brings a lawsuit seeking damages from another entity that they make a party to that lawsuit, they are not entitled to anonymity in doing so. The purpose of the complaint, the initial pleading filed in the lawsuit, is to disclose who it is that's seeking the damages and what damages they are seeking. All we are asking for in this legislation is that trusts that have been entrusted with funds that are to be made available for the exclusive purpose of helping the victims of asbestos problems have the opportunity to have information that they would have if it were a normal plaintiff's filing in a lawsuit. That is what we seek to have disclosed. I urge my colleagues to oppose this amendment and to support the underlying bill and reserve the balance of my time.
Gentleman reserves. Gentlelady from Texas.
How much time?
Gentlelady from Texas controls 1 1/2 minutes.
And the gentleman from Virginia?
Gentleman from Virginia has 2 1/2 minutes.
Let me yield to the gentleman from the great state of Michigan, the chairman, 40 seconds, half a minute, 45 seconds.
Right.
Do I get to choose which of those three here?
45 seconds.
Gentleman from Michigan is recognized for 45 seconds.
Thank you so much. I wanted to commend the creative inquiry of the gentlelady from Texas in examining this measure to make it clear to us through her amendment that this places disclosure burdens on trusts and asbestos victims, but not on the corporations, and that is what she seeks to deal with. And so this bill helps this be accomplished. And what is so critical about it is that we now have a more balanced approach than is currently in the bill. So please support the Jackson-Lee amendment. I thank the gentlelady for yielding.
I thank the distinguished gentleman for his important remarks. I reserve.
Gentlelady reserves. Gentleman from Virginia.
Mr. Chairman, I reserve the balance of my time.
Reserves. Gentlelady from Texas.
Thank you. May I ask unanimous consent to have the American Federation of Labor and Congress of Industrial Organization legislative alert letter be submitted into the record?
Request
unanimous consent.
covered by general leave. Thank
you. Let me quickly say, Mr. Conyers, Mr. Ranking Member, you were superbly right. The plaintiffs in litigation have had their right of exchange of information. What our friends are trying to do on the other side of the aisle is to make the trust now a courtroom where information is dragged out of the victims, but it is not asked for by the defendants, the ones who filed for bankruptcy, the ones who've left the victims to suffer and to fend for themselves. I ask my colleagues to make this fair and require the asbestos company to give us where their asbestos remaining products are so that we can save lives. If there is transparency, if the bill would be fair, if the fact bill would be fair, they would then have information coming from both parties, not only the victims, the plaintiffs, but they would have it coming from the asbestos companies that have driven up the numbers of those suffering from lung disease and cancer. I ask my colleagues to support the Jackson-Lee amendment, and I yield back.
Time has expired. Gentleman from Virginia.
Mr. Chairman, I yield myself the balance of the time in opposition to the amendment, and I just have to say that this amendment goes well beyond the scope of this legislation in terms of what it would do in terms of discovery in state courts and gathering various types of information that is already readily and easily discoverable in those proceedings, including, if necessary, in the bankruptcy court. What it doesn't get at, and the FACT Act does, is information that is not otherwise available to all of the parties to all of those proceedings to determine whether there are duplicative claims, whether there are fraudulent claims, whether there are claims where one party is claiming to have the same disease caused by two different places of employment, or having claimed the same disease caused by two different instrumentalities in two different places. That is what we need to know. That's why the FACT Act is necessary. I oppose the amendment, urge my colleagues to oppose the amendment, and I yield back the balance of my time.
Gentleman yields back. All time has expired. The questions on the amendment offered by the gentlewoman from Texas. Those in favor say aye. Aye. Those opposed say no. The opinion of the chair, the noes have it.
Mr. Chairman, I'd like to have the recorded vote in the yeas and nays.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Texas will be postponed. Where would he go now? For what purpose does the gentleman from Virginia rise?
Mr. Chairman, I move that the committee do now rise.
Questions on the motion, the committee rise. All those in favor say aye. Those opposed say no. The ayes have it. The motion is adopted. Accordingly, the committee rises.
Mr. Chairman.
Mr. Speaker, the Committee on the Whole House, the State of the Union, having had under consideration H.R. 982, directs me to report that it has come to no resolution thereon.
The Chair of the Committee of the Whole on the State of the Union reports that the committee has under consideration H.R. 982 and has come to no resolution thereon. Pursuant to Clause 12A of Rule 1, the House will stand in recess subject to the call of the Chair.
Members are taking a short break now.